Welcome to U.S. Immigration TV. Well, there was a recent court case that I think will have a positive impact on people whose visas were refused at the embassy, but they just cannot seem to get a clear explanation of why. Well, on October 5, 2022, the Ninth Circuit Court of Appeal held that consular officers are required to provide the factual bases for a visa denial or a refusal within a reasonable time, or they can be sued in federal court. Now, this case is very important because ordinarily a consular officer's decision to deny a visa is not subject to judicial review or oversight under what's called the doctrine of consular non-reviewability. Well, there are times, when a person is refused or denied a visa for a number of reasons. Let's say, for example, fraud or human smuggling. And when they try to get an explanation from the consul or the details about it, they are never provided with a clear answer. And ordinarily, there's nothing really they can do about it. Well, this recent Ninth Circuit Court of Appeal opinion carves out an exception or an exemption to this doctrine of consular non-reviewability in cases where the consular officer failed to provide a U.S. citizen spouse with a timely and adequate notice of the reasons behind the visa refusal. After all, think about it. If you don't know why your visa was denied or refused, how can you clear your name, clarify the issue, defend yourself, or demonstrate your eligibility for the visa? It's almost like being charged with a crime, but you don't know what the crime is. Now, in that particular case, a U.S. citizen petitioned her husband, and he went to the embassy for his interview sometime in 2015. Well, at the interview, his visa was refused based on the consul's finding that the husband was seeking to enter the U.S. to engage in what was called, quote, unlawful activity, and therefore he was inadmissible to the U.S. or not eligible to come to the U.S. But what does engaging in unlawful activity mean? Well, the couple continually requested that the embassy provide the factual bases or the reasons for the consul's determination that the husband was inadmissible and why the embassy thought he was going to be coming to the U.S. to engage in unlawful activity. What was the unlawful activity? Well, after years and getting no response, they finally filed a lawsuit in federal court contending that the government failed to provide them with the specific factual basis of the denial, and they otherwise failed to provide, and I quote, facially legitimate and bona fide reason for the refusal. Well, finally, 3 years later, and only after the lawsuit was filed, the government finally provided the factual basis for this refusal. Now, in this particular case, and it doesn't necessarily apply to you, but what they were contending was the consul thought that the husband was a gang member based on various tattoos he had on his body. That was it. Because of these tattoos, they thought he was going to engage in unlawful activity in the U.S., even though the family provided expert opinion from a world-renowned tattoo expert that these were not gang tattoos. Well, the fact that it took the embassy 3 years to finally explain the reasons for the refusal did not sit well with the Ninth Circuit, which noted that the government had waited, of course, almost 3 years to provide the information and did so only when they were prompted by a lawsuit. Well, the Ninth Circuit noted that, and I quote, it is a long-standing due process requirement that the government provide any required notice in a timely manner. And this is because the denial of an immigrant visa to the spouse of a citizen, and I quote, deprives that citizen of the ability to enjoy the benefits of her marriage and to live in her country of citizenship. Her ability to vindicate her liberty interests, whether through the presentation of additional evidence or initiation of a new petition, file a new petition, depends on timely and adequate notice of the reasons underlying the initial denial. Now, in this particular case, because it took the government almost 3 years to finally provide the reasons for the denial, the court found that the government did not meet the notice requirements of due process. And as a result, the government was not protected or shielded by that doctrine of consular non-reviewability, and this couple's lawsuit could proceed, and now the State Department or the embassy now has to defend itself and the reasons behind its refusal. Now, why is this case or decision so important to you? Well, the reason this decision is so important is that it should now force consuls to be more forthcoming in explaining why they have refused a visa. In fact, I have had many cases or consultations where a person was refused a visa, let's say for fraud or human smuggling. They may have been given a single sheet of paper with a box checked for the particular item. You committed fraud or you committed smuggling. And when attempts are made to find out what was the fraud or who was being smuggled, the consuls don't want to provide that information. So how can a person clear their name? How can they defend themselves if they're not provided with the reasons for the refusal? As I said before, it's like being accused of a crime, but you're not told what the crime is. This case is important because it now puts a duty or an obligation on consuls to provide an adequate explanation for the visa refusal within a reasonable time. So if you or someone you know was refused a visa but was not given a clear explanation of why the visa was refused, and you believe you did nothing wrong or the refusal was in error, you should consult with an attorney who can remind the consuls of their obligation to provide information or details of the refusal based on this new Ninth Circuit case. And the attorney, of course, can help evaluate if there is hope, such as waivers, or otherwise see if you can clear your name if the refusal was in error. Now, I hope that you found this video helpful and informative, and I will continue posting videos which I think may be of benefit to you, either new cases, new laws, changes in policies, and developments in immigration. So make sure, of course, to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.